effect, you trouble the members to do all of this copyright IP. I'm going to hand these out. And then once we've sort of done all that, you really do hope you will contribute and ask your questions and really make use of having these people from different perspectives. Yes, thank you.
Thanks very much. So after that kind of introduction to Mandela, I'll just assess a little bit of the scene around what I'm going to talk about. It's not going to be an exhaustive sort of coverage of intellectual property by any means, but I'll try and sort of set the landscape for you if you like. I suspect that Sarah and Jane will probably have much more practical things to say about it than I will, but I will endeavour to think about some of the issues alongside it as well. I'm more than happy to take questions as I go along, so if there is anything that occurs to you that you really want to get off your chest while I'm speaking, then please do interrupt, and I'll try and deal with it as best I can as far as that's concerned. So just to give you an overview of what I'm going to try and cover, first of all I'll just spend a very short time just explaining at a general level what intellectual property rights are. I'm then probably going to cover two main areas in a little bit more detail that I think are going to be particularly relevant to you. One is copyright and associated moral rights. The other one is confidential information. And then I'll conclude by really just trying to give you a bit of an idea in terms of how intellectual property rights can interact, ways you might want to think about how intellectual property rights can be useful to you, if that makes sense. So, moving on through, what's our IP rights? Well, first of all, they are there effectively to protect human intellectual creativity and innovation. They're a property right, and what that means is that they can be transferred just as the house can be. Similarly, they can be infringed in the same way as somebody might trespass on your land in the same way as well. They come in a couple of forms. Some IP rights are registered rights, and examples of those are registered trademarks and patents as well, and you actually have to register those rights with the trademark registry in the patent office, and they will take some sort of examination to make sure that they're valid rights that are entitled to. Other types, though, are unregistered, and copyright is a prime example of that. They just arise naturally. So I've covered the next part of the slide, the different types, just by going through that. There are a few others alongside that as well. I've listed confidential information and know-how separately, because that is a right under the property right. So you can't actually transfer ownership of confidential information. The thing that basically gives you rights over that information is the fact that you know it and nobody else does. So to the extent that it has any value, it's the fact that it's confidential, if you like. And so if you ever want to get some money for the value of that information, effectively you need to deal with it contractually, probably by promising the person that you're passing it on to that you wouldn't use it yourself, that you wouldn't tell anybody else about it. But it isn't a property right as such from that point of view. So, just moving on now to copyright. As I mentioned previously, it's an automatic right, so there's no need for registration as such. The question ultimately is whether copyright subsists in whatever it is that you've done. And I'll try and sort of illustrate that by the next point I'm going to go through. So, effectively, it will subsist in original literary, dramatic, musical, or artistic works. And I hope those are sort of fairly basic concepts that you understand in terms of what I mean by that. So, effectively, when you're writing something, as long as it covers the threshold of originality, if you like, and I'll just come back and explain a little bit more about that in a minute. As long as it covers that threshold, you will have copyright in that writing from that point of view. It does also cover things like sound recordings, films, broadcasts, and also, possibly also relevant to you, but more to the publishers, typographical arrangements, and what that effectively means is the way that it's actually arranged on the page, the way that the article, whatever it may be, is arranged on the page. There is a certain level of effort that goes into that, and copyright subsists. The other thing to bear in mind is that it's territorial in nature, and what I mean by that is that the country in which it's created, that the author comes from, if you like, or that it's first published in, the laws of that country will really decide whether copyright subsists in it. Having said that, it can be enforced internationally. There are international conventions that mean that if you've got copyright in your home country, as long as that form of copyright is also recognised in another country internationally, you will be able to enforce it in that country, as long as they've signed up to the Berne Convention. In most countries that you care about are going to be signed up to the Berne Convention. So that's kind of the scene setting. I'm going to concentrate now on literary works, because I suspect that's probably going to be the most relevant thing for you. If there are other areas that you want to explore, I'm more happy to go into them, but that's probably where my main focus will be. So I guess the first thing to bear in mind here is that for something to be a literary work, it's got to be recorded in writing. That may sound flippant, but you can actually have copyright in the spoken word, as long as it is recorded in some way. So the maker of the speech, he may not have written anything down himself, but if somebody has recorded that speech in writing, that will be protectable in copyright, and it will be protectable as literary work in those circumstances, because it's been recorded in writing.
Sorry, can I ask that writing is print and digital now?
Yes, absolutely,
yeah.
most definitely. And thanks for that clarification. As I mentioned previously, it must also be original as well. And in fact, there's been a bit of development as to what we believe to be original and what the test is for originality, if you like, over the last few years. As copyright has started to be affected by the European lawmakers. So the traditional view under UK law of what was required for originality was some sort of sweat of brow effort. So it didn't actually require that much creativity as such, it was actually the hard work of writing something. The European lawmakers have introduced this concept of intellectual creativity. Now, again, I don't want to overplay that distinction because I suspect it doesn't make an awful lot of difference ultimately. I think it's still a pretty low threshold. Nevertheless, it is slightly different to this idea of sweat of brow that we sort of UK lawyers have a tendency to think of. Generally speaking, I've referenced there the fact that it's got to be the author's own intellectual creation. Who is the author? The author is obviously going to be the person who creates it. I've referenced the typographical arrangement of the published edition. There, that will be the publisher. The term copyright is also an important one for you to think about. It's a significant term. It's going to be the author's life plus 70 years beyond that. So it's certainly going to cover a significant time period. So the next important thing to bear in mind is who is actually the first owner of copyright work when it's made. Again, generally speaking, it's going to be fairly obvious. It's going to be the author of that work. The only time when that won't be the case is if the work's created by an employee during the course of his employment. And in those circumstances, the employer is going to be the owner of the work. But there is a fine distinction in law between somebody who is an employee and somebody who maybe is just a consultant, a freelancer, whatever it may be. And it's important to bear that in mind when you're weighing up the ownership from that point of view. Yeah, of course.
The work that you have before you doesn't have an author. So say
Sorry,
the work before you doesn't have an author that you can relate to, say, a heritage recipe that you might find in a museum or somewhere, in some old records.
Sure.
Who would be the author of that?
How do you
distinguish the author of that?
Okay, so I mean that's actually quite a current topic in the copyright world. It's something in the art, if you like, that's known as an authored work. Generally speaking, the new legislation that's been brought in around that effectively requires you to make a diligent search of the author. And ordinarily, if you can show that you can collect that, then you should be able to use that work yourself. The only thing to bear in mind is that in the event that you are challenged by the author in due course, you will have to pay them some sort of reasonable license. So they can't charge you something extortion for it, but you've got to be prepared to have to pay that license if you do that effectively. That's assuming it's still a copyright. So if it is a heritage recipe that's 200 years ago, then you know you're going to have fairly safe ground.
So it's nice, like say at a museum and you ask them to take a photograph of it and keep the records and use it to publish it. That should be okay.
That should be okay, as I've said, as long as you are within that sort of time period. The only issue there is whether the museum will let you photograph it. That's the only thing, but that's a completely different issue.
Can I ask a question in terms of this particular piece? So if you're in
So, again, yeah, of course. So the question that was asked is, if you are in a situation where you've got a contract with your employer, will it be the case that your employer will own copyright? And I think the point I was trying to make earlier is it really does depend upon whether it is actually a contract of employment, because I'm conscious that there is a very sort of quite significant distinction between somebody who might be contracted on a per article basis or something like that, who isn't necessarily employed as such, as against somebody who is an employee. So their employer is making PAYE tax contributions, they're paying the national insurance, those sorts of issues as well. So there is quite a fine distinction there. In reality, most employers would have an assignment of copyright within the term of the contract anyway, and in most circumstances, I suspect, if you're dealing with a publisher who knows what they're doing, there will either be an assignment or some sort of license of your copyright as well. So this is just what the situation is in law. It can be very contractual as well, if that makes sense, and I will come on to that in due course. Does that answer your question?
Yeah, thank you.
The other thing to bear in mind is that you can actually have joint ownership of copyright as well, and the situation where that arises is if there is collaboration between the two authors and the contribution of one author is not really distinct from the contribution made by the other author. You can't really draw the distinction between the two. In those circumstances, you will have joint ownership, and that can be quite a complex relationship because you've got to get agreement between the two authors as the owners of the copyright before you can really do anything to explore the copyright as well. So, generally speaking, again, if you're entering into some sort of collaboration over a piece, it's worth getting that kind of agreement as to how it will be exploited in writing beforehand if you can. Does that make sense? So I'm now going to get into what can constitute infringement of copyright. So the first thing I was going to lay out for you there is really just what are the restricted acts. So what can you as a copyright owner restrict others from doing with your copyright work? First and most obvious one is copying that work. And when I refer to copying, it's basically copying of the whole work, or even a substantial part of the work. And I'll try and explain a little bit more about what I mean by substantial parts in a second. You can also prevent people from issuing copies to the public, forming, showing or playing the work in public, probably less relevant here, renting or lending the work, communicating the work to the public, and that's an important one as far as the internet is concerned, because that would cover things such as linking through to content that isn't freely available on the internet. So if something's behind a paywall or isn't generally available on the internet, and an internet is provided through to it, that would be an infringement, because it would be communicating the work to a different public, if you like. Does that make sense? And finally, making an adaptation, which again is probably less relevant here, I suspect. So, what is primary infringement? Effectively, it's doing any of those things without the consent of the copyright owner. There must be actual copying, so what it doesn't cover is somebody who might come up with something very similar, but has never ever referenced the original work. It's a coincidence that they've come up with something that is very similar to the original work. That is always one of the difficult issues in copyright work, is actually proving that it has been copied, unless you can show that the person has had access to it. The other thing that I've got back there in brackets, which is that it doesn't necessarily require knowledge, is quite a tricky concept to get your idea around. And I think probably the better example I can give of that is a recent example in the music industry. So you had the US copyright case recently with Robin Thicke and Pharrell Williams around Blurred Lines. And one of the issues there is the fact that they may have had the Marvin Gaye tune in their heads when they were writing that song. They may not necessarily have been aware that they were referencing it and using it in their composing, but nevertheless they were copied from that point of view. And you can see that kind of issue. It can apply in writing as well. You can have a piece of writing with disability. For instance, in an employment situation, you as an employee may have written a piece to your employer, you may leave work, you may start work with another employer, and you may reproduce that work working for your employer, even though you don't have it in front of you, just because you're so familiar with it. And you've got to be very careful about those kinds of things as well.
If it's not
Yeah, I mean, that's where the lines become very blurred, if you pardon the pun. Because effectively, what copyright doesn't cover, it doesn't cover ideas. It's not quite as simple as it only covers the expression of those ideas, but effectively, what it won't cover is you coming up with the same ideas and expressing them in a piece of writing. Nevertheless, it can become more than that. So I'm trying to think of the right way of putting this. You might effectively say exactly the same things, but you might just use slightly different language. So if you're effectively your article is setting out the same ideas in the same way, but just using slightly different words, doesn't necessarily get you off the hook. Does that make sense? It's quite a hard concept to get across that kind
But
of
if
thing.
you had a particular story to tell and you wanted to tell it to a different publication,
Sure.
then the story is the same as such, it might be based on research, so you've still got the same information there, but
Yeah.
you've written it in a different way.
So I suppose maybe the best example to give you this is, I don't know if you remember the Da Vinci Code case. So that case was involving a factual book, somebody who had written this theory about the fact that Mary Magdalene had lived and had gone on to found a dynasty, if you like. And that was written from a factual point of view, as a historical work of fact. You then had Dan Brown came along who'd read that book and got some of those facts out of there, and then wrote a book, work of fiction, effectively. That was found not to be infringement because effectively he was taking the ideas and he was using them in a very different context. Having said that, I think to distinguish it, if somebody took the same storyline from the Da Vinci Code and wrote a book that was pretty much the same storyline but was using different words, there's no doubt that it would probably become copyright infringement. If that makes sense. Do you get that distinction from that?
Yes, but I was thinking of it as the same author rather than somebody coming in with
Yeah.
a particular idea. If you've written it for one market, you decided to write it for another market, you're not going to do exactly the same, but the underlying story might be the same.
Yeah, I mean, you need to be careful there because obviously, as the author, if you're the owner of the copyright, that's fine. If you're not the owner of the copyright, that is where your lines start blurring, and you do need to be very careful. I think if you start from the same premise, I mean, do you have a particular example in mind here? I mean,
Yes, it doesn't actually relate to food, but I've done some research, and it was historical research for World War I. So
Right.
that story is based on research, but then I might consider writing that up, having written it for one market, to write it for another market. It might be an overseas market. So it's the same story, but in different words, so pulling out different things.
if it's pulling out different things, that might be sufficient, but you do have to be very careful about that because just because it's a different market doesn't make any difference because it goes back to the point I was making earlier, which is that copyright applies internationally.
I thought there was some sort of... I thought you could do first British serial rights, first Italian serial rights.
That will come down to the way you're dealing contractually with things. But ultimately, if you've been given a complete assignment of your copyright in the first work, you will no longer be owner of the copyright in that work, and the owner of the copyright in that work can enforce that copyright against you as the author if you then write something that is a substantial copy of the first work, even if you're only marketing in a different country. does that make sense?
Makes worse.
So who's paid you for the first one? And
Yeah.
whether they're going to be bothered if
I
you
think so. And then I think if, on the publisher's side, if you said, I've done this, but I'm going to rewrite it for South Africa, blah, 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 do you mind? Most of the time, no, that's fine.
Yeah.
It's not a problem. Sometimes you need to do that up front. I have a question about that, which is a bit of a similar thing there. When I started out in recipe writing magazines 100 years ago, and I remember being told by very senior editors, oh, you can take somebody's recipe and you can just change a few ingredients. That's what I found.
Yeah.
And I thought, really? And there's still a little bit of that in the old school, actually.
Yeah.
And I've had a few issues with people in my company who've done just that and have said, well, that's all right, I'm like, well, the image is the same.
Yeah.
Really?
And I I think you have to be very careful because I
That could
think.
be sued, it might be plagiarism.
Well, yeah. I mean, ultimately, my advice to clients is always, if your starting point is somebody else's work, that means you're copying. And then the only issue is whether you have made your work sufficiently different that it's no longer a substantial copy.
But how do you know? Because with recipe writing, I have this particular question because I'm writing a book at the moment and I'm getting really bothered about whether the recipes are actually going to be mine in the true sense of the word because they're so particularly in the field that I work in, baking for example, there's so many expanded recipes. So, what point does it become yours and not somebody else's?
I think this particular one, for example, was a sort of multi-layered meringue with satsumas and pomegranate, and the original recipe actually looked extremely similar to the one that was recreated. So, had it been my original recipe, I would have had no problem with that. But I think, like lamb and anchovies and rosemary, everybody claims it's theirs. But whose was it? Baked camembert, and I just noticed that it's his. It's kind of. I think that baking is so classic, isn't it? Victoria sponge, or a twist on the scone. Salted caramel.
Ultimately, the issue is this: even with those standard recipes, are you starting with somebody's version of that recipe and then basing your recipe on that? Because if you are, then you're copying. If ultimately you're thinking, actually, how do I make this? I know how to make this. You make it, and then you write down what you do as you go along, and then maybe you finesse it as you go. You're creating original work. You're not copying something.
Well, I don't think I ever will because they're asking if you want to make a recipe that works, you've got to have certain portions of ingredients. Otherwise, you're going to have a disaster. So,
But I don't think anybody would. If anybody, I've had it over many years of people saying so-and-so did this and that was mine, blah blah blah. But really, lots of times, actually, my friend's mum gave that to me. Or, and she's Turkish, and that's why that's why I got that twist on this. And so I think with recipes themselves, it's very hard unless you actually speak that recipe.
And I think, generally speaking, again, you've got to think of it in terms of, if you like, where the work is going in, where the intellectual creation is going in. Quite often, the list of ingredients is something that everybody knows is there and generally knows the proportion. It's probably less about intellectual creativity going in. It's possibly around the English that's used to describe what you have to do.
so it's the method. So actually, you have a completely different, not a completely different method. You actually put it a range of extra instructions or slightly different instructions, and you know it's yours. So.
That's the part of that always that the ingredients basically don't matter, it's the terminology of the method.
Oh,
Yeah.
that's right. Yeah. Because most of the recipes, because one of my pieces have enough instructions and recipes anyway, so when I write a recipe, I was write a lot more, give a lot more information, so it's fundamentally different from a recipe, although the ingredients they won't be the same, but they will be similar.
I think that's right though, so because Samaya and I have a lot of crossover foods, and because of the region that we come from. So as you were saying, the ingredients are going to be largely the same. You might have a pinch more of something than I would.
Well, you always realise that it's the method.
Your way of writing it will be completely
And
Yeah.
it's also because we come from different parts of the region. So I think it's because we realise so many times that our ingredients and the final product is similar, but it's the methods that we were taught. that are so
And,
different.
and would the storytelling that goes behind that count as part of the copy?
Yeah, absolutely. And that's, to be honest with you, that's where the majority of the creativity is going. That's where the protectionism tends to be aimed at. It's very difficult to claim copyright on this. It's the stuff that goes around it. It's the important bit.
Facts. There's no copyright on facts.
Yeah, No.
It's just the way facts are expressed and
that's right. But it's not quite as similar as that because it's also, if you're using the same facts in the same way, and this ultimately is the way that somebody who writes a book can sell the rights to a film, for instance. It transfers in that way. That's an adaptation of the same story. It's not expressed in the same way, but it's taking the intellectual creativity from that original story. If that makes sense. So it isn't quite as simple as that, which is why I'm kind of, I wanted to urge caution when you said, if I just change a few of the words, that's going to be okay, isn't it?
You think, well, I've done years of research on this, and then am I sort of stumped at the first hurdle that I've written it for this publication, so I...
But it depends on what you've sold. I mean, what have you sold to the first people? I mean, if you have sold your copyright, that's one thing. But you may not have done that. You have to look and see what your agreement with them says. That's the critical thing. And what territories it covers, and you know, I mean, I think that's the frightening thing at the moment, is that publishers tend to want everything from us.
This all sounds very hypothetical to me, in as much as I have a friend in the Guild who has studied intellectual property rights for many years, and has gradually come to the conclusion that what the law says is not so significant as who is enforcing the law and what happens when there is a legal contention, and in which case it tends to be largely decided by the relative power, prestige, and wealth of the two parties involved.
There is quite a lot in that. I wouldn't disagree with that. And I think the advice I would put around it is it's one of the reasons to get things straight at the contractual stage, I guess. Because
And knowing that, corporations behave accordingly.
they can do. I think it depends on the corporation, to be fair. If that makes sense.
I think it's better to read it before you sign.
Yeah.
Yes.
I'm a big corporation here, sorry. And if you read it and if you don't like it, don't sign it.
No.
And really read it.
And you know, with the online world, power is sort of shifting over to the individuals to an extent as well. You know, you've got abilities to self-publish now if you don't like the terms being offered. So you've got a negotiating position of some sort. from that point of view. So yeah, I was just finishing off with there doesn't need to be any knowledge of copy, so you can do it in adverts. There. So following on, as I mentioned, it's got to be a copy of either the whole work or a substantial part of the work. And I guess there are 2 points I wanted to make there. One is the obvious one, that quantitatively, you've taken 3/4 of the piece, therefore you've copied a substantial part. But you can actually copy a substantial part by only taking very little, because ultimately, again, it can be a qualitative assessment. So again, that sort of consideration is looking at the intellectual creation that's gone into the work and making an assessment of the bit that's been copied, whether that is a substantial part of the real sort of intellectual creativity that went into the work from that point of view. And to give you an example as far as that's concerned, there have been a few cases coming out of the newspaper industry around the kind of newspaper clipping services that are now offered online, which generally speaking, they will index a whole newspaper website. They will then provide to corporates a service offering them details of the articles that come up online that are relevant to the corporate. And the way they will do that is they will effectively provide a link with the text taken out of the article referencing that particular corporate. There might be a few words before it and a few words after it. And the finding in court has been that can be a substantial part of the article in those instances, because the chances are that excerpt will be sufficient for the person who's looking for it to understand what is in the article without actually having to go to the article. Does that make sense in terms of explaining that sort of things?
Can I raise a point which was sort of in reverse? I wrote an ice cream book years ago, which was for Porto, who, you know, you sign your life over to them, you give it everything, and you get £2,000 or £3,000 for it. And this particular book has sold, well, I don't know, it's well over 100,000 copies, but quite a lot more, as I understand it. They also don't keep you up to date with reprints and how many books have been sold. So I had arranged with another food writer, a lady called Alex Barker, who lives in the same village. She'd also written an ice cream book, and we had arranged to do an ice cream demonstration together. So she owns a picture library, and I said to her, we've got some lovely pictures that we can use to promote this. So she sent me a few. Well, a few weeks later, Xanthi Clay, who was then our president, was was tweeting about my ice cream book, and I thought, well, that's strange. Why would she be tweeting about that? Looked at the picture, and it was a completely different edition to anything I'd seen before. So I contacted the publisher and said, oh, it's gone out again. They sent me a copy. And they had very kindly given me about a dozen recipes which I hadn't written. So there were extra recipes in my cookbook with my name on it, which weren't mine. So I was flicking through and identifying them. And I thought, all those pictures look familiar. And I mean, what a nightmare for them. They had taken 12 of Alex's recipes, because she'd already also written for the same company, and put those recipes into my book.
Yeah.
They had also changed one or two things in my book. I think I'd done a coffee roulade and they wanted it to be a chocolate roulade, but they changed the caster sugar in that to icing sugar, which really annoyed me because I thought it simply wouldn't work. So, you know, somebody was fooling around with the recipe. So, but what really annoyed me was she's a great girl, but she's much more commercial than I am. And she created this recipe with bloody chocolate sprinkles on it, and I would never use chocolate sprinkles. And that was what drove me round the bend. And so I contacted them. Of course, it was years ago, so I didn't have the contract. You know, I'd grown up in my office work. But I did get them to agree that they had infringed my intellectual copyright, despite me having sold the copyright to them for the book. They had infringed my intellectual properties by attributing somebody else's work to mine in such a way that the public would think that these recipes were mine.
So that's actually moral rights rather than
Yes,
copyright,
yes.
and I'll come on to that.
Yeah, but they had taken the decision to do that in the way in which they had described that they had created the book.
Yeah.
And they did agree that they had gone too far, but I wasn't strong enough and willing to put enough money into fighting them over it.
No.
I suggested they sent me a case of whiskey, and that never arrived.
You have just given the perfect illustration of the point that I made.
Yeah, and you know, I just felt that I could do nothing about it. They said they hadn't printed many, and they would
So what
do
would you
the
suggest
amendment.
someone to do now?
So, I mean, the courts are trying to sort of resolve this problem of it being very difficult to enforce rights such as yours in a cost-effective way. So they are trying to come up with lower cost options. So there is now something called the Intellectual Property Enterprise Court, which is claimed up to £500,000. That particular court is that particular sort of tranche of claims, if you like, will still be expensive to enforce. But within that, there is also now a small claims procedure for claims up to £10,000. And the intention behind that is that somebody ought to be able to enforce their rights on an individual basis without actually necessarily having to go and use a professional lawyer. I wouldn't necessarily advise you to do it because I personally think that intellectual property rights are an expensive, are a complicated issue. Nevertheless, there is a possibility for that, and I think particularly in sorts of circumstances where you're involved, where you do have moral rights, where they seem to have acknowledged it, it might actually just be something that even the threat of it, the fact that you know that that's available to you, might make them sit up and take notice and treat you in a serious manner. Because more often than not, for corporate involved, and to be fair, Joe maybe I'll speak to this better than I do, but most corporates will, if they think they can get away with it without it being too much hassle for them, they will try and get away with it. Once it starts becoming an annoyance for them and something they have to deal with, then they will start trying to get it off their desk, if you like. And I think as long as you're all reasonable in terms of what you expect from them, they will probably try and deal with it.
I would think that.
Yeah, I'd go for the case of Scotch.
Yeah.
You go for what?
I'd be for the case of Scotch.
Yeah.
Rather than into legal language.
Yes.
You know, just an hourly rate.
Yeah. No. Well, I just suggested to them. Of course, they went very quiet. But you know, I think that is the big issue, and I feel that it's something that for a lot of food writers, and it's different now from what it was in my day. You know, it's tough for these young people who are trying to make a living from food writing, and to be paid X thousand pounds for a work the way you assign the rights is an attractive idea.
Yeah.
I never wanted to write an ice cream book. I'm amazed at how well it's done. And I certainly don't want ruddy sprinkles out.
I would think that bringing such a suit would be a virtual guarantee that you never get another copyright. You would end up like Edward Snowden.
No, they don't talk to each other and the publishers.
Oh, they do.
Which is
Oh, they do. Oh, absolutely. I turned up for an interview once about a contract and they said, I hear you're a difficult author. And I always handed in on time. So, yeah, they do. I think it's a small world.
Right, fine. I was going to ask, what's the limitation on something like this? So if you say discover that your works republish or use or, say you have like something that you realise from funding, what's the limitation on
6 years. That's a good point. I mean, I hadn't even thought about that, but that's quite key. Yes.
What, 6 years until they can treat it to it?
So 6 years from the infringement, but bear in mind with copyright infringement that if you like, it's been consistently infringed because presumably the copies are out there, they're being sold and so forth. And so that's quite a, it's the only issue is around how far back you can claim damages effectively. So
6 years from the time that it was published or 6 years from the time that it was republished? So say it was like 5 editions.
it's different acts of infringement. So each one will be a different one. All it will mean is, say for instance, it was originally published 10 years ago, it was then republished within 6 years. You can still claim damages for 6 years. You can't for the 10 years unless that edition is still being sold within the 6 years. Does that make sense? So I will come back onto moral rights, but I think being as we're on it now, the other thing I would mention as far as moral rights are concerned is what I don't know is what likely damages could be for infringement of moral rights. And the reason for that is I'm not aware of any case that's been brought in the UK to do with moral rights. It's actually a French concept that's got introduced into European law. And in France, authors, not copywriters, authors can get huge amounts by way of settlement for breach of moral rights. We just don't have any idea really over in the UK as to how significant the level of damages would be. And generally speaking, English courts I think would be likely to be considered on the conservative side as far as that's concerned. So what else have we got there? So yeah, another act of primary infringement is also authorising somebody else to do an act of infringement as well, possibly again less relevant. Secondary infringement then deals with kind of the secondary acts of infringement, if you like, so not the publishing, not the copying, it's then the dealing in the infringing copies, so possessing an infringing copy, selling, distributing or importing an infringing copy. Those are all secondary acts of infringement. And the reason why that is worth making a distinction over is that requires knowledge. So if you're selling something and you don't know it's an infringing copy, then you will, once you're told that it's an infringing copy, you will have to stop selling it, but you won't have to pay damages for those that you have sold already. Does that make sense? The other thing to bear in mind as far as secondary infringements are concerned, and to be honest, it's good form all around when dealing with copyright, is to use the copyright notice, the standard copyright notice. So it's the C in the circle, your name, and the date that you've written it, published it, whatever it may be. That's a way of putting people on notice that you do have copyright in it, and they do need to have done their due diligence as to where it's coming from effectively. So I'm just going to deal very briefly with committed acts, because I'm not sure how relevant this will be in this particular area, but I'll just go through some of them. They're generally seen as the fair dealing exception, and you'll see that fair dealing is a concept that comes through all the way through, and I'll deal a little bit about what fair dealing is about a bit later on, but those are just some examples. So first one is non-commercial research and private study. So where somebody, a student for instance, is researching something, maybe takes a photocopy of a particular piece, whatever it may be, you're entitled to do that. The only thing to bear in mind there is that it does have to be fair dealing. Therefore, if you're copying a whole book, for instance, or a whole article, that may be seen as going beyond the fair dealing exception and maybe infringement still. You're also allowed to copy for purposes of criticism, review, and reporting current affairs. It requires an acknowledgement of the source that it comes from, and again, fair dealing applies. A real-world example of this may be, for instance, where on the BBC News they might show you a few-second snippet of a football match showing the goals. They're not the owners of the copyright on the Sky broadcast over that piece, but because they're reporting current events, they're allowed to do that. And what you'll notice whenever they show that is they've got the Sky logo up on the piece to show this comes from Sky. Personal copying for private use is also allowed. This is a new one, and this is really intended to enable you, when you bought the CD of a piece of music, to be able to put it on your iPod and copy it across to your different media. Again, though, it could be relevant in terms of what you've got, especially with online. Parody, caricature, pastiche is also a new one. Again, fair dealing applies as far as that's concerned. And finally, for teaching purposes. So, if a teacher wants to use an excerpt of a copyright work to illustrate something, they're allowed to do that. If it's more significant copies, then generally, in the education world, there tend to be licensing schemes to cover that kind of copying behaviour. Just more generally, sort of touching on fair dealing, different considerations come into play for the different exceptions, but I think as a rule of thumb, one way of thinking about fair dealing is that, generally speaking, if the copying is something that, generally speaking, is going to undermine the standard commercial exploitation of that work, chances are it won't be fair dealing. So effectively, if somebody comes up with a parody of a copyright work, but actually anybody who reads that parody will really get the benefit of what the original work was as well, that's unlikely to be fair dealing, I would venture. There's no hard and fast rule for it, but that will give you an indication of where you're overstepping the mark as far as fair dealing is concerned. So now I'm just going to come up to some of the transactional aspects in terms of dealing with copyright. The first thing I wanted to draw is the distinction between assigning copyright and licensing copyright. Assigning transfers the title of the copyright. So when you are assigning your copyright, you are no longer the owner of the copyright. Somebody else becomes the owner of that copyright and can exploit it how they choose to within the confines of rights legislation. The other side of things, though, is you can license your rights, so you're retaining title in this instance, and you're granting somebody exploitation rights instead from that point of view. Next slide, we'll then go into that in a little bit more detail. First of all, dealing with assignments of copyright. There are a few things to bear in mind as far as assignments of copyright is concerned. First of all, for legal title to be transferred, it's got to be in writing and it's got to be signed by the copyright owner. The reason why I drew this distinction with the legal title is that if, even though you don't have a written assignment that's signed by the copyright owner, you have actually agreed to assign the title, then you can still assign the beneficial ownership. And what that effectively means is that you've got this rather unsatisfactory position where somebody can, in a court of law if they have to, as long as they can prove the agreement, can say, I am the owner of the copyright, but it's going to be very difficult for them to assign that copyright without getting the legal owner to do that. It's quite a complicated concept. It's just something to bear in mind, because if you haven't actually signed something, then you may again still have a little bit of power of negotiation with whoever you're dealing with who has the beneficial ownership, because they will still need you to effectively assign over the legal title before they seek to enforce it from that point of view. It can also be whole or partial, so you can actually assign your copyright to the online version of a piece of writing, or you could assign your rights to the film rights to a piece of writing, but still retain all of the other copyright from that point of view. One interesting area where this has been relevant in terms of written journalism more generally has been with the advent of technology in the online world. So, generally speaking, if you don't have in your contemplation at the time that you're agreeing to assign copyright the methods that your copyright might be exploited, generally the law will say that you aren't assigning your copyright in those particular rights. And so there were some quite significant cases, particularly over in the US, around journalism, written articles, print articles, that were then digitised by the newspapers and put online. And a lot of the journalists objected to that and made the claim that they hadn't actually assigned their copyright to be digitised versions, and they were successful in their claims as far as that's concerned. Whether that would come out in the same way as in the UK or not is more difficult to take view on, but I think the general view is that it probably would do actually, as far as that's concerned. I suspect this particular technological revolution is over now, and generally speaking, a lot of publishing houses are alive to it and tend to build in language that will cover that kind of eventuality anyway. But it's just something to bear in mind.
Just ask about photographs.
Sure.
I quite often see photographs of not that I have a copyright on, just appearing all over the place, particularly obviously online. It's the first I've seen when I was using them, so asking them,
Sure.
what's this, what's the,
I mean,
it seems like a minor thing, it's almost,
well, no,
irritating.
it's not a minor thing, actually, it's quite a significant issue. Within journalism, there's an awful lot of issues of photographs, the photographers have genuine copyright, and it was one of the drivers behind setting up this claims procedure for enforcing copyright. So it's a very common problem. It's also one of the main drivers behind the orphan word legislation as well, because an awful lot of online photographs are photographs where you don't know who the actual author was. Does that make sense?
So I could go to whoever it is and say, but surely they shouldn't actually put the photos up there anyway.
I'd say it's
So I have a legitimate right to go to whoever it is who actually posts this photo and say,
yeah, absolutely.
Do you own the rights to the
yes, I
photo?
have the rights to everything.
Yeah.
Well,
Well, self-published.
No, but absolutely. I mean, that's a real problem, actually. People are screenwriting and sitting on their
Yes.
blogs and,
Yes.
and all they think, if they give you a little credit, that's fine, they're asking you permission or paying you a fee or... So, no, absolutely, going all guns blazing, I would.
I mean, often if you just Google normally, for example, you'll see images, and quite a few images that pop up that are actually taken.
Yeah.
But it's quite handy, that's one reason to Google yourself, actually, it's not for vanity, but it's amazing how much of your work you find over the web.
But you can actually use the image search to see if your pictures are online somewhere else.
Yeah.
It's
Google
yeah,
Images.
Google Images,
Yes, yeah.
and there's an option to sort of check whether something on your website or your blog is actually sort of elsewhere online.
A question, what is the legal significance of the statement that you now see in books so often? I don't have the wording exactly right, but so-and-so assumes responsibility for the content of this work. Does this ring a bell? I don't have exactly right, but it's something close to that.
It sounds like that might be more guarding against defamation type claims or something like that, maybe.
I don't know. I just see it commonly in books that are totally uncontroversial.
Oh, really?
No.
It's in contracts. It absolutely is in contracts. Now the publisher says that the author is responsible. And if you took it at the letter of what the contract said, you'd never sign another contract again, because it sounds like you are being exposed to all risks of saying that you own the copyright and you're free to sell it, and if there's any problem, then it's up to the author to defend themselves against it, and the publisher is not going to be at risk, and that's difficult.
I mean, it is. I mean, I just sort of looking at that one, I suppose ultimately that's where you've got to be clear as to what you're entitled to do and what you can't do. So you're in control, if you like, when you're going to infringe someone's copyright. The only thing you're not in control of is somebody thinking that you infringe their copyright
exactly.
too. And that's where you want to get the balance right between your own personal risk and the publisher's risk from that point of view. The difficulty is the publisher doesn't know either way, I guess. So the other thing, just just to bear in mind is you can also assign prospective copyright. So you may not have written anything yet, you may agree to write something, but you can still assign the copyright in what you're about to write from that point of view. Right, I was just going to touch upon licenses now. Similarly, there are lots of ways of dividing your rights up when you come to licensing it. And I've broken it down into three main ways. Just giving a little bit of detail around some of this. So the first thing to bear in mind is that you can have three different types of license which can restrict who can use your copyright work in a particular way in different ways. An exclusive license, first of all, means that only the licensee can perform the acts that are licensed by the license. So you as the copyright owner can't perform those acts, and you can't license anybody else to do it. It's only the exclusive licensee. The second type of license is a sole license, where both you and the licensee can perform those acts, but you can't license anybody else to perform those acts. And then the final thing is a non-exclusive license, where the licensee can perform the acts licensed, but the licensor can license anybody else to perform those acts as well. You can also limit the rights of the license, and I apologise, that final main bullet point should be on its own, so this applies to all of those types of license. You can limit the rights that are licensed in a number of ways. So first of all, by the term of the license, the length of time over which the license runs for. Also by the territory covered, so this comes into the issue about licensing the rights maybe for the UK, but retaining the rights for South Africa, for instance. And finally, by the nature of the exploitation that you're licensing. So you might, for instance, license somebody to use your literary work, your article, whatever it may be, in print, but you might license somebody else to use it online. Does that make sense as far as that's concerned? So again, we've really touched on quite a lot of this already, so I'll just cover some of the main points in terms of moral rights. As I mentioned, it sits alongside copyright. It's something that ultimately can't be assigned in some ways copyright, so it always belongs to the author. The only way that it can be transferred is by death, and it passing to whoever you bequeath it to effectively from that point of view. I've set out the three main ones there. The first one is the right of paternity and maternity, the right to be identified as the author effectively. For this one to apply, you've actually got to assert it. So you've got to tell whoever you're assigning your copyright to, licensing it, whatever it may be, that you're asserting your right to be identified as the author of the work. The other two are the right of integrity. So the right to object to derogatory treatment of the work. So in the example given earlier, the fact that they changed the type of sugar that's being used, you might argue as a derogatory treatment in the work. The use of chocolate sprinkles similarly from that point of view. And then finally, the right not to suffer false attribution, which again we've covered from that point of view. The term is the same term as the term for copyright, so 5 plus 70 years, except in the case of the false attribution right, which is the right plus 20 years. I'm not sure entirely why that is the case, but that is what it is anyway. The other thing to bear in mind is that although they can't be assigned, they can be waived in writing. So it isn't an uncommon contractual term for you to be required when you're assigning a copyright to also waive your moral rights as well. And that's really where the publisher is just wanting to, they don't have any concerns about the sort of example we were talking about there. And it's something to bear in mind, within the whole commercial negotiation. It's probably better to be honest up front and say, we want you to waive your rights, these are the consequences of what may come from it. And if ultimately your feeling is, well, actually the money is worth it, then you may be prepared to do it from that point of view. But at least you've had that conversation up front and be honest about it as well. So just going through the remedies for infringement. The first one is either damages or accounts of profits. And that is your option as the copyright owner. And just to explain what that effectively means. Damages are there. They're basically the monetary value that the court attributes to the damage you as the copyright owner have suffered. So if you're selling something and you've lost sales as a result of the infringement, you're entitled to recoup the profit you've lost because of the sales you've lost as a result of that. An account of profits is the direct opposite of that. That is the defendant, the person who's infringed, having to account to you for the profit they've made arising from their infringement from that point of view. So you always have that option between you, and generally speaking, if you've been successful in a copyright claim, you're entitled first to get some basic information about the level of sales that the other side have made, the costs that they've incurred, the revenue they've generated from the infringement, so you can make an assessment of ballpark figure of profit that they've made, and you can compare it against the kind of damage that you've suffered as well. So that's the first remedy. The second remedy is the injunction, so you can stop them from carrying on with their infringement activity. So if they've printed 1 million editions of this particular work, you can stop them from selling any more of that work, at least until they've taken out the infringing content. And finally, you've got delivery up or destruction. So if they've copied your work in its entirety and it's all that they're selling is your work effectively, you can get them to deliver it back, or you can get them to destroy it. If your work happens to be part of a much greater work, then you may otherwise be able to ask the court to order that they rip it out of the book, for instance, in some way, or maybe redact it so that it can't be seen anymore. Those sorts of situations are more tricky. There will be instances where this remedy is more discretionary, and if the court feels ultimately that the damage to the defendant in having to take that kind of action is going to be greater than really the damage that you will suffer as a copyright owner. They may say that they don't have to do that, but they have to pay you a license fee instead for the fact that they're going to carry on selling the work with your copyright work within it. Does that make sense? So I was just going to cover very briefly, and I'm conscious I've gone well beyond what I'd said in terms of 30 minutes. I think it's probably covering some of the things that Sarah and Joan are going to cover anyway, I think. Anyway. Confidential information very quickly. I guess where this is possibly relevant is where you've got some ideas around something that you might want to do that you're discussing with somebody. You haven't actually written very much down, you haven't gone through the idea yet. This is the circumstance where you do want to be keeping it confidential, you don't really want to be sharing it with that very many people. So, first of all, what is confidential information? It is kind of what it says on the tin. It's information which has that necessary quality of confidence. It's something that you haven't told anybody else. People don't know about generally. They may come up with the same idea as you independently, but it's not because you've told anybody about it from that point of view. And again, it's information that is disclosed in circumstances that an important obligation of confidence. So it's in circumstances where you're telling somebody and it's fairly obvious that you're wanting them to keep it confidential as well from that point of view. That's what confidential information is. And that obligation of confidence that is owed by the person you're imparting information to, that can arise in one of two ways. One is contractually, where you've actually signed some sort of confidentiality agreement, non-disclosure agreement, identifying the fact that you're going to be giving them confidential information, explaining what it is that they can use that information for, and making it clear they can't tell anybody else about it, and they can't use it for their own commercial purposes. It can also be applied though, you don't have to have a contract. So again, if the circumstances of the relationship you have are that it should be confidential, it should be expected to be confidential, you can still take action against any breach of that confidence, as far as that's concerned. I've put up examples there. The most famous example of something that's confidential is a recipe. Coca-Cola recipe has never been protected by anything other than the fact that Coca-Cola keep it secret. So that's your primary example of confidential information. Business plans, all of these other commercial issues are obviously confidential as well, but I think Coca-Cola recipe is a prime example. So, some practical tips around confidential information. First up is limit its circulation and access. Don't go around speaking to lots and lots of people about your ideas. Be very selective as to who it is that you're going to approach about them, and make it clear that you only want to discuss it with a limited number of people. Be clear as to who it is that they are going to have to discuss it with if they want to take it forward, and be comfortable with the fact that they're going to be discussing it with that many people. Second thing is, to the extent that you've got anything written, and in terms of actually keeping it confidential, it is always a bad idea to have something written in any event. But to the extent you have something written, mark it confidential. The reason why I say it isn't bad to have something written down in writing is because of the copyright options you've got there as well. But mark it confidential so it's clear that anybody's hands it falls into, that it is confidential and not to be sharing it around. And actually, if they're not clear why they received it, they probably will want to have it and want to destroy it. And then finally, it is worth having a confidentiality agreement. We come back to the point that the gentleman over here raised earlier, that the reality is it costs an awful lot of money to enforce confidentiality agreements. You can get into very tricky issues. But if you've got the agreements up front, if you're dealing with ethical people, they ought to be respectful of that. And again, it's just one of those further ways in which you're drawing their attention to the fact that you believe is that your confidential information. One caveat to all of this that is not uncommon and won't be uncommon in your circumstances is that when you're approaching commercial organisations and you say, I've got something that I want to discuss in confidence with you, they may be reluctant to do that. And one of the reasons why they may be reluctant is that actually they may be developing that very same idea that you've got already. And the difficulty with that is that they don't know what your idea is, and they therefore don't know if they've got an idea that they've got to develop. So they may be reluctant about it, and you just need to bear that in mind. And a not uncommon carve-out of confidentiality agreements is that it won't cover something that they know about already and effectively, and you do need to be conscious of that. And it is, again, one of those reasons why the actual enforcement of confidentiality agreement can be difficult. The only issue around that is that clearly they have to prove where they got it from and that they had it before you spoke to them, if that's the case. And that's always something that is key to an argument like that if they're trying to put that against you. I'm just going to finish off now with just a slide about the interaction of IP rights, and I've kind of touched on it already where I've been talking about confidential information and the fact that actually it's not a bad idea to have something down in writing that you can get copyrighted. Bearing in mind the limitations about copyright as well, but at least you've got a copyright word there as well. One of the areas where that can be pertinent is in issues about TV formats, for instance. Generally speaking, there have been a number of cases around TV formats based on copyright where there hasn't really been much cause of action because ultimately copyright work hasn't been sufficiently explained. Sorry, the idea hasn't been sufficiently explained in the copyright work to claim copyright infringement. But if you've got a very, very detailed document that ultimately is developed into a TV format, the chances are you will have some sort of copyright you can claim. It will be very difficult to enforce, but you will have something there. So again, it's worth thinking about that as a further safety net if you want it. And if the idea is commercial, you might have it. Final thing, and this is probably more personal in terms of those of you that are self-publishing and are blogging online, is to bear in mind the value of trademarks as well. Trademarks ultimately help to protect your brand equity, your goodwill. Therefore, all of the good work that you've done in your journalistic careers comes down to the brand that you've got out there. And where you are self-publishing, where you are blogging and so forth, actually think about the branding you use around that. Think about whether you want something that's quite a distinctive name for your blog, for instance, something that you can really rely on in terms of trademark rights as well, because that's something that can really build up separate value for you, in addition to the very good contact with your publishing alongside. So that's how I want to finish. I'm more than happy to take any further questions, but equally I'm conscious that probably Sarah and Jane have got quite a few things they probably want to say about that.